Hello, and welcome to our latest webinar, our second of 2021. I'm Jeremy Glover, a partner here at Fenwick Elliott. Now, we've featured a wide-ranging number of themes over the past weeks in our webinars, but not yet what happens after completion. Happily, I'm pleased to say that we are rectifying that omission today, and I'm very pleased to be joined by two of my colleagues here at Fenwick Elliott, partner Jatinder Garcha and senior associate Ed Colclough, who are both key members of our projects team. This means that they're perfectly placed to consider issues relating to liability post-completion, to discussing some of the potential residual risks for employers and contractors, as well as looking at the significance and implications of certificates issued following completion. But before I hand you over to them, the usual housekeeping. You know that you're on mute, and if you have any questions, please feel free to drop them into the question box. I promise that all questions will be asked anonymously. So without further ado, Jatinder, over to you.
Thank you very much, Jeremy. Good afternoon, everybody. Welcome to this webinar, which I hope will be useful and informative. In this session, we'll be covering a number of topics, as Jeremy just said. What we will look at is, we'll look generally at contractual liabilities, and we will take you through very briefly through the lifespan of contractual liabilities from commencement to practical completion, take you through the significance of practical completion, how you get practical completion or takeover. We will then, in some detail, discuss defects, patent and latent, and in particular, we will look at defects obligations under contracts and how they differ. And ultimately, what we will look at is the implications of some of the certificates that are issued, the final certificates. What does it mean for going forward at latent or other defects liabilities? And we will also look, when we're doing this discussion, we will look to compare certain standard contracts, in particular the JCT, the NEC, FEDEX, and ICME. And then, if we have some time, we will look at limitation of liability, and we will answer as many questions as we possibly can. Edward will take you through the first part. I will jump in and talk about defects, and then Edward will jump back in and talk about limitation of liability. So without further ado, I will hand you over to Edward.
Thanks, Jatinder. So before we get too caught up in thinking about liabilities post-completion, it's probably worth having a recap on contractual liabilities in general, what they are and where they come from. So I guess scrolling down this list, you've got the most obvious one at the top, express contractual obligations. Primary one from an employer is typically going to be payment of the contract sum, and on behalf of the contractor, it's going to be delivering the agreed scope by the agreed time for completion. Now, behind that, you're probably going to have a whole host of pages and pages of express contractual terms governing, enhancing, and setting up how you get there. And that can be anything from complying with third parties, complying with third-party documents, and liquidated damages mechanism, failure to get there on time. Now, to the extent you're light on your express contractual terms, you'll have implied terms that will also come into your contract that will impose liabilities. Typical ones that we often see in a construction context would be concepts of prevention, the principle that the employer cannot prevent the contractor from completing on time, but yet cash in from delayed damages at the end. You also have concepts in terms of goods and materials. They should be reasonably fit for the purpose that they're used for. So the implied contractual obligations almost sit there as a safety net in general, so possession of site and what have you. Going further down, you've got statutory requirements. So they're the laws of the lands. In a construction contract text, an obvious one over here would be the Construction Act. It applies to all construction contracts, a very prescriptive payment mechanism, a right to suspend for non-payment of certified sums, and a right to adjudicate. Now, just because, for example, a right to adjudicate hasn't made its way into the contract, that right still exists in the contract, and it very much exists post-practical completion. Just on statutory requirements, it's probably worth just noting the CDM regulations and Health and Safety at Work Act, because not only do they impose civil obligations, there's also criminal sanctions, prosecutions and fines that can be attached as well. So that's also worth just bearing in mind. And then I guess, depending on whether you're in a common law jurisdiction or a civil law jurisdiction, you're going to have your contract sitting within a body of case law or the civil code itself. And then at the bottom here, we've got tort. So that would typically be claims against a professional team for breaches of duties of reasonable skill and care. And typically you see that for defects or issues that arise in terms of engineering or design. So on this next slide, as Jatinder said, we've got a timeline of contractual liability. And it's probably worth just running through the various stages with you. So at the outset, you typically get pre-contract negotiations, and that's really trying to negotiate the key terms of the deal. And you might sometimes see what we've got there, subject to contract, stamped on various documents. The clear intention behind that is, look, these are negotiations, but there's no intention to take on contractual liability at this stage. As discussions progress, you may well get closer towards a deal, and a letter of intent may be let to keep the project on track for discrete elements of the work to keep them up and running. With a bit of luck, then hopefully you can be looking towards getting into contract, and there you're very much into your construction phase. The end of the construction phase comes here, and we've got there down at the bottom, completion takeover. We're going to focus in a bit more on what we mean when we say completion and takeover, and seeing what sort of watershed moment it is on the project. Then you're very much up and running in your defects notification period. There's an obligation as well as a right for the contractor to come back to remedy defects that are notified within that period. And then towards the end, there's a concept of a final light certificate, giving a tick to the project and acknowledging that things that were meant to have been done have been done. After that, we're very much looking forward, and we're going pretty much into the Wild West here in terms of looking at statutory limitation periods, how they bite, 6 years, 12 years. We'll focus on that in a bit more detail towards the end. And of course, there are certain acts that ignore the limitation periods. For example, the Bribery Act, that just continues to run and run and run, liability for that. And for example, fraud, that runs 6 years from when the fraud is actually identified. So in theory, that just continues running. And then towards the end, right down at the end, we've got an interesting concept here, design life requirements. Now, Jatinder, we often see those being put into contracts, 20, 25, 50 plus year design life obligations. And it's worth just pausing to think how that actually sits with your contractual liability, and particularly these hurdles where liability can fall off from a limitation perspective. And I guess the starting point to notice that statutory limitation period can be extended, it can also be shortened, but from a contractor's point of view, you want to be pretty careful in terms of these design life requirements, that you're not getting through the back door tagged on to taking on liabilities over and beyond what you think you're doing. And best way of dealing with that is going to be express drafting in the contract. We know from recent case law that arguments of design life obligations sitting towards the back of a contract against express reasonable skill and care obligations towards the beginning of the contract, the design life obligations have trumped that. So from a contractor's point of view, you want to keep clear of those arguments and be careful on that point. I guess then, just taking a step back, when we're negotiating these documents, there's often a mad rush to get them agreed and get on site. And whenever we say, well, what's the rush? It often is to get to completion. And I think that's really the commercial reality to bear in mind. Completion does drive a lot of these projects. That's when the works, the asset can start generating money. That's when loans can start being paid off. So it is a key event, but sometimes there's the thought behind getting to completion, things are done and dusted. But I think if you look at that line, there's a good argument that at completion, you're not at the finish line in terms of how your liability is packaged up going forward. And in fact, there's a good argument you're not even halfway there yet. So that's something that's worth just bearing in mind as we go through. So here we're going to have a look at what we mean by practical completion, what's its significance, and is it that watershed moment? So by and large, I think the general consensus is practical completion, the contractor significantly completed his obligations under the contract. By and large, he's done what he was meant to do. As a result, they should get a certificate which triggers various events. So just scrolling down here, the employer takes back possession of the site and the works, the contractor's insurance of the works ends, and the risk then flips to the employer to insure. The contractor's exposure to delay damages, that ends. That only ends for damages going forward. Any damages that have accrued to date, he'd obviously still be liable for. Contractor's obligation to undertake variations ends, so the employee can't actually instruct variations post-completion. Often when I've seen variations wanted to be instructed post-completion, it can get quite tricky, and a lot of best practice guidance says you should actually enter into a new contract, but typically you'd see the contract amended to keep the same kind of warranty protection, but it can get quite tricky, those instances. PC typically will signal the first instalment of retention monies, I guess acknowledging that the risk profile on the project has somewhat decreased. Now you've got to completion, and likewise, if you've negotiated a bond, sometimes they can release at PC. However, funders and employees typically like to keep their hands on the bond for as long as possible towards the end of the defects period that is triggered by PC. Again, final account discussions often get underway in PC, so there's still some quite tricky discussions to be had in terms of entitlements, and then snagging and punch lists are also issued with the PC certificate. One thing that I should probably add at the bottom there, for the purpose of the Limitation Act, breach of contract claims, PC typically will start the clock running on that as well. So, given the significance of practical completion, you'd think that there would be quite prescriptive definitions in terms of what it means, but by and large, the standard forms tend to leave practical completion with little or no definition at all. And I think that's really supported with this cost plan services case, which itself acknowledges that practical completion is easier to recognise than define. Taking the approach, you're probably best leaving it to the common sense of the technical certifier with the background knowledge. For obvious reasons there, latent defects, defects that cannot be identified, cannot prevent practical completion. The works are intended to be complete and free from patent defects, that's obvious defects, other than ones to be ignored as trifling. Now, I sometimes wonder on a day-to-day basis how helpful that trifling definition is, but I mean, the point is not that there's not to be getting at trivial defects that don't really affect the intended purpose or use of the works going forward. Down here, we've got a concept that patent defects, there's no work between the distinction between whether work's not completed or work needs to be remedied. And I guess an example there would be a door handle not being put on, that's work's not completed, or door handle being put on the wrong way, that's defective work, but is treated the same way in terms of work not in accordance with the contract. And then at the bottom here, again, the case just confirmed that the fact that a defect cannot be remedied does not necessarily mean that the works are not practically complete. Now, at first reading, that might sound a bit strange, but I guess it makes sense, and it's pretty much a throwback to your famous swimming pool cases, Ruxley Falls site, where just because a swimming pool is a few inches or so out of specification, to the extent it can still be used for the purposes it was intended, it shouldn't be fully refunded, and you're looking more at a de minimis damages claim there. So I think that's the point there. You shouldn't really be holding up practical completion for issues that, even though they can't be remedied, don't stop the proper use of the works going forward. Now, because there's such a vague or definition around practical completion, to the extent you want to be specific, you quite often see contracts amended to include express preconditions to practical completion. Typically, you'll see that capturing as-built, owner manuals, health and safety files. Collateral warranties is an interesting one. Contractors really don't like that. They don't like being exposed to the full LAD bill going forward just because a collateral warranty hasn't been provided, which shouldn't, in theory, prevent the employer from enjoying or using the property as intended. But I take the point, you need as many sticks and carrots to get collateral warranties. And then just a point down there at the bottom, watch out for deemed completion. That's when an employer is getting fed up, hastily takes back possession of the site. That can inadvertently trigger a lot of the implications we've seen up above in terms of practical completion being deemed to take place. So that's just a point that needs to be taken into mind when early possession is being taken by the employer. So we've got here just a comparison of some of the standard forms, how they look to address takeover completion, how they define it. Interestingly, looking there, NEC seems to be the one that really does go to town and give an express definition of what it means by completion. You can see there the contract has done all work which the scope states is to be done by the completion date and corrected all notified defects which would prevent the client from using the works or others from doing their work. Just going down at the FEDEX, they have the concept at 10.1 that the works are completed in accordance with the contract. You've also typically got a testing regime that takes place before under the FEDEX contracts, together with conditions to provide as-built, any trainings and O&M manuals. FEDEX also provides that minor outstanding work and defects is allowed, so I guess that's pretty much going back to the trifling point above. And then below on your yellow and silver books, in terms of the design and build and the EPC contracts, you've got the concept that the contractor must complete the works that are necessary to fulfill the employee's requirements that are set out there. And then you get the issue of your taking over certificate by the engineer. One thing to watch out for is the FEDEX does contain a deeming provision. If the engineer doesn't move in time within 28 days and certify takeover, there can be a deemed provision under the FEDEX contract in certain circumstances, which is certainly something to watch out for. JCT again leaves a pretty bland definition of practical completion. However, clause 227 of the design and build requires practical completion of the works and delivery of as-built and the health and safety file for CDM purposes. Interesting, JCT doesn't introduce a concept of a snagging mechanism, which means most snagging mechanisms are either done outside of the contractual arrangement, or you need to draft and amend the JCT to adequately provide for that. And then the PC statement is issued by the employer under the JCT. We've looked at the NEC, it's the project manager who again there certifies completion, and I think they're obliged to respond within a week of being given notice. And then the ICME, typically used on process plants, that's got a sort of two-stage mechanism. So you've got substantial completion of the construction element of things, you get the certificate, and then you're well into your takeover tests, which again are witnessed by the project manager, and then you get the certificate issuing takeover there. So following takeover, certificate or completion, whatever you want to call it, you're triggered into the defects regime, and I think Jatinder's going to pick up there and discuss some points.
Thank you very much, Ed. Thank you very much for that. Yeah, so this part of the webinar, I'll be looking at defects obligations by specific reference to industry standard contracts, highlighting different approaches, but also common issues. So I suppose when we start looking at defects, I suppose the first point, the natural place to start is, what is a defect? So as we will see on the next slide, contracts tend to define what we mean by defects, but where there is no contractual definition, the case of Yarmouth versus France from 1887 provides a useful guidance. It provides that a defect is anything which renders the plant, etc., unfit for use for which it is intended when used in a reasonable way and with reasonable care. So, but as I say, when we come on to looking at contracts, you'll find that defects does tend to be defined, but if it isn't, bear in mind this old Yarmouth case and what defects might mean under the common law. Now, one thing to bear in mind is just because something is defective doesn't necessarily mean under the construction contract that there is a defect. Take, for example, something that's been designed by a contractor. Provided that the contractors use the reasonable skill and care or the required reasonable skill and care under the contract, if there's still some defective works, yes, the works are defective, but not necessarily a defect. And that's obviously very important when you're coming to look at whether there's a defects claim or not. Now, defects themselves are divided into patent defects, being defects that were discoverable, i.e. they don't have to have been discovered, but should have been discoverable or apparent from a reasonable inspection. And then you have something called latent defects, which are defects that are concealed and come to light at a much later date. Now, the significance of the distinction between patent and latent defects will be discussed by Edward a bit later on in relation to the Limitation Act and how that applies. But in relation to contractual obligations and defects liability obligations, it's the patent defects that we're normally dealing with during this period. Now, in relation to patent defects during the defects liability period, I would like to just probably highlight two common points. that come up for discussion all the time. First one, a common question I get is, if a defect certificate has been issued, even though there are known patent defects, does that mean that the contractor no longer has any liability for that defect? i.e. the employer has now issued a notice saying everything's done. Well, thankfully, there was a recent 2019 case in relation to the Liberty Stadium, the home of Swansea Football Club. And that case has provided some clarity on this point. Now, in that case, which actually related to a limitation period, there was an express limitation period linked to the issue of the notice of making good defects, and which was issued, and the parties were having a discussion about whether the limitation period applied because there were some known defects at the time that the notice was issued. What the court held on that occasion was that the defects were deemed to have been made good for the purposes of the defects liability provisions, i.e. specifically for the DLP, contractual DLP obligations, those defects were deemed to have been completed. So whatever flowed from the issue of the notice of making good has contractual effect, and therefore in this occasion the limitation did apply. However, they held that the notice of making good did not, however, bar a subsequent claim for making good defects pursuant to the core obligations of the contract. So what effectively they were saying was, if there hadn't been this obligation or this limitation on liability clause, the employer under those circumstances would still have had a claim for those patent defects, even though the notice of making good had been issued. Hope that's clear. The second common issue that I get is, from contractors, is if they get made known of a patent defect, i.e. a defect that could have been discoverable before the notice for making good was issued, they argue that they should have been notified of that defect before the end of the DLP, and accordingly, they should be offered the opportunity to come back and fix that obligation, that defect, rather than allowing the employer to claim claim damages for breach. Now, obviously, the benefit for the contractor of that is coming back and correcting that defect is going to be much smaller liability than damages that the employer could claim, including for additional losses. So again, it's an interesting one as to whether the contractor at that point has the ability to come back and correct that defect. Now, before looking at contractual requirements, I would just like to dispel one common misconception, and that is that a contractor does not have a common law right to return to site to remedy a defect, unless the contract expressly confers such a right. So normally, if a contractor is liable, common law dictates that the employer can correct the defective work himself and sue the contractor for the loss. Now, from the employer's perspective, that can actually be quite a painful process. So it's usual for a defect of that nature, the solution is for the employer to include a right in the contract to allow the contractor to come back. And obviously that also gets over the employer's obligations in relation to mitigation of loss. So without such a contractual right to come back and remedy a defect, the contractor doesn't have a right to come back and remedy that defect, and the employer can recover its losses in the normal way, subject to mitigation of loss. However, as we'll come on and see, most standard forms do include that simpler solution of displacing the common law rules with a contractual procedure, which we refer to as the defects liability provisions, which normally last for, depending on the contract, between 6 and 12 months. But as Edward said earlier on, once a contract has included that right or those DLP obligations, then it is a right for the contractor to come back and remedy, not just an obligation. So now what I'll do is I'll just look at defects correction liabilities and consequences of issuing the defects liability certificate. with specific reference to the four standard contracts on the screen. Now, the first thing I suppose to consider is to what extent do the standard forms actually define defect? So looking at turn at the four contracts, the JCT does not have what I would say a capitalized definition. So if you look in the definition section of the JCT contract, you will not see a definition for defects. But what clause 2.35 does, it talks about any defect, shrinkage, or other fault due to a failure of the contractor to comply with its obligations under the contract. The reference to defect is therefore linked to a failure by the contractor. Now, the NEC does have a capitalized definition of defect, which includes, as you can see on there, things such as works not being in accordance with the scope. And the ICME contract has a similar definition. And both kind of, again, imply that there needs to be some sort of breach on the contractor's behalf, which all kind of sounds logical. There must be a breach. But the reason I highlight that point is the FEDEX contract, on the other hand, refers to defects and damages to the works, but unlike the other contracts, does not specifically refer to any need for a breach by the contractor. And that is deliberate, which we'll come on to in a minute, because under that contract, the contractor is actually obliged to remedy defective work, whether or not it's the contractor's fault, which is a bit of an odd situation if you think about it. Secondly, all of the contracts themselves include a mechanism of notifying defects, timeframes within which they must be remedied, consequences, etc. Those are set out briefly again on the slide on the screen. I don't intend to run through those mechanisms with you in detail, but what I will do is highlight potentially some unusual provisions for you to think about. So, firstly, in the JCT contract, having said that the DLP is a right for the contractor to come back and remedy defects, if you read clause 2.35, you'll see that it allows the employer actually to instruct that a defect is not corrected, and instead that it can make an appropriate deduction from the contract sum. Now, what does that mean? We don't know. There's no definition of what appropriate sum might mean in these circumstances, but I think it must mean, I would have thought, some reference to the cost that it would have cost the contractor to remedy that defect. Now, even more unusually, the FEDEX contract is different to the other contracts in that it requires the contractor to come back to site and remedy defects or works in the damage, even if it's not caused by its default, excluding any wear and tear. That's the only exclusion that the FEDEX contract has. Now, if you think about that goes well beyond just normal defects correction. That effectively amounts, I would say, to some sort of maintenance obligation. And given that the FEDEX contract is used internationally, where following completion, parties might have left the country, that's quite an obligation when you think about it in the maintenance sense. But what FEDEX does say is that clause 11.2 sets out where the contractor is liable for costs of rectification. And these include things like errors in the contractor's design, defective goods and workmanship, and failures to comply generally with the contract. And what it goes on to say is that any other cause will entitle the contractor to a deemed variation. So whilst it's saying the contractor must come back to site, it is acknowledging that it must have a variation for that. And clause 11.4 of the contract then goes on to entitle the employer to various other certain rights. If the contractor fails to make good those defects for which it was responsible, and that's quite clear, for defects where the contractor would have been responsible for the cost, the employer has ability to employ third parties, and there's various other rights as well. Interestingly, however, what the contract doesn't cover is what happens if the contractor fails to come back and remedy a defect, which is not a defect, i.e. not something that is its responsibility to fix at its cost. Now, the contract is silent on that point, but again, I think the general consensus must be that in those circumstances, it would amount to a breach of contract, and the employer would have to recover its losses in the normal way, subject to mitigation. And then just finally, what I want to touch upon is what is the significance and the consequences of issuing defects liability notice or the final certificate notice, because that does differ again between the standard contracts. Now, obviously, we know from a contractual perspective, reaching the end of the defects liability period will have consequences such as release of second tranches of retention, final payment will become due, there may be some return of performance bonds. But what happens in relation to defects? Does that certificate give the contractor an ability to be off the hook for any defects going forward? Is this it? Can they walk away from the contract now? I'm going to start first of all with the ICME contract, which states that the final certificate, which is issued after the end of the defects notification period, constitutes conclusive evidence in any proceedings whatsoever that the contractor has completed all the plant and made good all defects in accordance with its obligations. And this is quite an important provision, is in particular reference to made good all defects, because the courts confirmed in a case called Matthew Hall versus Tarmac back in 1997 that this wording means that the contractor has no further liability for latent defects from the issue of the final certificate going forward. Now, I'm actually currently working on a matter at the moment where the employer has missed this point and assumed that the latent defects obligations would apply going forward, but has been caught out by the fact that the final certificate, it's quite clear in the ICME, there are no claims for latent defects after that point. The JCT contract, on the other hand, after the issue of the notice for making good defects, the final statement is calculated and paid. And if you look at clause 1.8.1 of the JCT contract, it sets out, it's actually one of the contracts where it expressly sets out what the consequences are of that final statement. And the consequences are namely, one, where there was anywhere in the contract where the employer's approval was required for matters like goods or materials, etc., then it is deemed that those materials incorporated in the contract are to the employer's reasonable satisfaction. But it shall not be conclusive that they comply with any other requirements of the contract. So it's saying the employer can't come back at a later state and say, oh, actually, when I said I didn't approve that, it wasn't to my satisfaction. That is an argument that they won't be able to convince the courts on. But if there's any other provision of the contract that has been breached, then they do still have a right to bring a latent defects claim. It's conclusive evidence of all extensions of time and loss in expense. So there's no opening up of EOTs or loss in expense once the final certificate or final statement has been paid. And 1.9 in fact goes on further to say that no payment shall in itself be conclusive evidence that the works are in accordance with the contract. So it's quite clear here, very much leaves it open to the employer to bring claims for latent defects. The NEC contract, again, doesn't talk very much about the consequences of any of these certificates, but what it does say in clause 44.3 is that the employer's right in respect of a defect which the supervisor has not found or notified are not affected by the issue of the defect certificate. Quite clear, again, keeps open the right to bring claims for any latent defects going forward. And then finally, FEDEX. Now, the FEDEX contract is an interesting one again for various reasons, but in 11.9, it talks about completion of the contractor's obligations under the contract and talks about the performance certificate shall constitute acceptance of the works. Now, that wording has led to, I know, for a number of contractors to believe that that means that once the performance certificate is issued, the employer no longer has any claims for latent defects, i.e. that provision extinguishes any right to bring any further claims. I suppose it's an argument that's similar to what the ICME contract says, and the way that there's a drop-off of latent defects obligations at the issue of that final certificate. However, when it comes to the FEDEX contract, whilst there's probably some open debate about what that wording means, I don't think that wording goes as far as, or is substantially different to what is set out in the ICME. So, for my opinion on that is that I fear that the contractor would not be able to argue that it no longer had any liability for defects, and the normal 6-year or 12-year liability period for latent defects would continue to apply, unless expressly and contractually it's been excluded. For people who are familiar with the FEDEX contract, I think your clause 11.10 also, I think, gives some backing to my opinion on that, on the basis that, again, 11.10 talks about there being the parties remaining liable for their fulfillment of any obligations that remain to be performed at the time of the issue of the final certificate or the performance certificate. And even in the 2017 wording, a new provision has now gone in to state that the contractor shall not be liable for any defects or damage occurring 2 years after the expiry of the DMP for plant, unless prohibited by law. So that clearly seems to state that I think FEDEX have understood that there is a latent defects obligation, but they are now trying to carve out latent defects for plant in particular just to 2 years. Anyway, hopefully I will now hand you back to Ed, who will take you through the final bits.
Thanks, Jatinder. Just very quickly on limitations, as you say, back to contractual basics, freedom to contract. You can limit it to whatever you want within reason. There's some red flags in terms of limiting liability for death or personal injury, but we won't go down there. Within reason, the parties can agree what they want. So if you don't have an express provision in your contract, you're going to be looking to the Limitations Act. So from a contractual breach of contract claim, you're looking at 6 years from the cause of action, or if it's signed as a deed, 12 years from the cause of action, which is typically why in construction you go for your deeds. Cause of action for breach of contract claim, as I mentioned at the top, typically go from practical completion. Claims in tort, you can end up with this funny situation or slightly odd situation where the limitation has run out under your contractual claim, but because in tort the limitation period runs from when the damage was suffered, let's say the cracks in the walls appearing, you could have a longer extension, so you could be more beneficial bringing the claim in tort. And then I think, as Jatinder alluded to in the last slide, there's enhanced protection for latent defects. It's 3 years from the date the defect was discovered or discoverable, with a 15-year long stop from the date the negligence occurred. And then final point on that, to the extent you are shortening the Limitation Act, you want to be very clear that you are excluding it as well, just so you're not caught out by it still applying. And I think, Jeremy, that would be back to you with any questions.
Excellent. Well, thank you both very much. That very thorough and entertaining and interesting discussion, and it certainly generated a number of questions. Jatinder, you were talking about defects and when defects are defined in some contracts, they're not defined in all contracts. Someone's asked about fair wear and tear. Is that a defect or not? How does it fit when we're talking about that part of the contract?
Ed, do you want to take that one?
Yeah, I mean, it's an interesting point. If you look at the ICME, I think when it defines defect, it then actually goes on to say, and by the way, a defect is not fair wear and tear. It's not if the plant's been operated outside of the O&M manuals. It's not if the contractor's breached the contract in certain respects. So that does acknowledge it. I mean, in the past, I've tried to get that clarification into contracts, and people don't like it. I guess the concern is, particularly on the O&M manuals, that contractors will load into the enhanced obligations in the O&M manuals. So they've always got the argument that the employer hasn't complied with them, and therefore it's not the contractor's fault. So games can be played there, but in principle, no, I completely agree. Fair wear and tear shouldn't be a defect.
Okay, brilliant. I've got a slightly longer question about insurance policies. Do the standard forms of contract and typical project insurance policies normally provide cover to the main contractor and its subcontractors for any damage to the works post practical completion caused by the remedial works?
I'll have a look at this one. Just thinking about it, let's just take an example of the JCT contract. I'm just working this through in my head. The obligations in relation to insurance, in particular in relation to who takes out the all risks policy, which is normally the policy that will cover the insurance of the works during the works period, those insurance policies come to an end at practical completion. So the obligation on the employer, on the contractor or the employer, if it's an existing building, to maintain insurance for those works will expire at practical completion. So that's a good point. So when the contractor goes back onto site to remedy the works and causes a further damage to the property, the question I think is being asked is, how is that going to be insured and who picks up the responsibility for it? Now, because the all risk policy is no longer available, unless there has been some sort of extension, I suppose what we're looking at there is the contractor is either going to be going in to remedy this defect at risk, because whilst the employer will have a property, will have an insurance in place to cover the property and damage to the property, the question is, if a claim is brought under that policy and the policy pays out, no doubt those insurers will look to subrogate that right against the contractor who caused the damage. Now, and I'm assuming at that point there will be no express exclusion for those works from the policy, and in all likelihood the claim then would be brought against the contractor's public liability policy. So the claim was likely to be paid in the first instance under the employer's property policy, with recovery against the contractor's probably public liability policy, unless the contractor has some sort of general all risk policy which covers these kind of going back to the site and correcting defects. So I think that's probably where it is. I think it's slightly a risk for the contractor, I would say. Yeah.
Okay, no, brilliant. Thank you for that. I appreciate that. That was quite a detailed question. We're just about running out of time, so I've got a more general question to finish with. It's probably one of those deceptively simple questions. Should we be putting subject to contract on all pre-contract negotiations?
It's a good question. I mean, in establishment contracts, the courts will look at the intent of the parties. Now, subject to contract is a very good marker of intent not to be bound, but I don't think you can put it on everything in the hope you're never going to attract contractual liabilities. It's going to be a matter of the real intentions of the parties. And you do sometimes see subject for contracts still in contracts that are signed, and clearly that wasn't the intention. So it's not a complete get out of jail card, but it's a very good mark of intent and good practice to put it on, particularly when you're getting into the realm of letters of intent, where it's becoming, it's a bit blurred between what your obligations are and what they are going forward. All the terms aren't agreed. I think you do want to be clear on what you're not agreed on and what you are agreed on. So yeah, good idea.
Okay, that's brilliant. Well, Jatinder, Edward, thank you both very much for this morning. There's just time for me to let you all know that we're coming back in 2 weeks' time, when Senior Partner Simon Tolson will be joined by Lucinda Robinson, another partner here at Fenwick Elliott, and Mark Hackett, who will be well known to many of you as a quantum expert. And they're going to be doing exactly what it says on the slide, lifting the fog on provisional sums. So hopefully can join you. You'll all want to join us again Thursday, 11th of February 2021. Until then, thank you very much for attending and participating in our webinar, and stay safe, and we'll hopefully see you all soon.